The chair recognizes Senator the Honorable Darren Henfield.
Thank you, Madam President. I am on my best behavior today, I promise. I have no choice, as Madam Justice Ruby Nottage is sitting in the gallery. President says you need to come more often. And so I want to join you in welcoming Justice Nottage, who taught me in university. One of my favorite tutors, and quite frankly, one of my favorite human beings. Love her very much. Well, yeah. And she's joined by Carol Ashley, whom I had an opportunity to work with as a student in seeking to sink my teeth into the law. Everybody knows that Bertha Cooper Russo is a pioneer in this area of law. She's been working at it for basically all of her life. She don't recall, but I know her from being a pupil with Lauren Klein, who's a colleague as well. Well, Brandis, it's good to see you. Brandis Donkinson, who's also a learned friend and colleague, and Dominic Nottage. Your work precedes you. It is my prayer that we in this place today do justice to this labor of love that you have undertaken on behalf and in the interest of our country for all of these very, very long years now. The concentration, though, forgive me, the concentration of my presentation is really the Arbitration Amendment Bill 2023. And I shall seek to focus thereon and avoid getting into any political rancor. I'll do my best. So, Madam President, among other things, the legislation we debate today amends the Arbitration Act of 2009 to include provisions related to the resolution of trust disputes through arbitration. I believe this is a very important factor in the amendment that we make today. Arbitration, which is, as we've heard here, an alternative form of dispute resolution, for various and varied reasons, has grown in popularity over the years. These amendments are also anticipated to, among other things, to expand and replace existing arbitration of trust disputes, the Trustee Act, as affected by the Trustee Amendment Act of 2011. In that act, it provided that mechanisms whereby trust disputes could potentially be resolved through arbitration in our Bahamian jurisdiction. This was a very important step for us. The 2009 Arbitration Act enabled, in Section 91A, enabled the engagement of arbitration toward the resolution of such trusts. The amendments we pass today are expected to, among other things, expand and replace the existing arbitration of trust dispute provisions in the mentioned trustee legislation. The Honorable Prime Minister asserted in that other place, albeit optimistically, that these amendments will promote economic growth by offering investors the assurance of acceptable dispute resolution framework. I pray he's correct. It is believed, then, that these amendments will serve to enhance our already robust offerings in trust for wealth management and attracting corporate bodies as well as individuals to our jurisdiction. Madam President, we have been for many years now seeking to position and offer the Bahamas as a viable jurisdiction for international commercial arbitration. It has been our concerted view across administrations that we are ideally suited, geographically positioned, to provide for and welcome this most propitious form of dispute resolution to the industrial countries from the industrial countries of the world that are in fact, to the industrial countries of the world that are in fact our neighbors. Simply put, Madam President, arbitration offers the opportunity of settling a legal dispute without the burdens of a court trial. As such, a dispute is submitted by agreement of the parties to one or more arbitrators who make a binding decision on the dispute. As difficult as it is for most of my learned friends who make their living in the litigious environment of our legal system to admit, and more often embrace arbitration, it offers many benefits to potential litigants that are worthy of examination. The sheer length and expense of a civil trial should be motivation enough, I believe. Most of us readily accept that going through a trial can be expensive, can also be very time-consuming and nerve-wracking. So, alternative dispute resolution, such as we find in arbitration, provides a way out of that sort of litigious environment. Well, the outcome more than often is uncertain. The amount of monies that one will be called upon to spend in the system is uncertain. And so arbitration, in my mind, provides a far better alternative. The problem is that colleagues from mine from the legal fraternity, I believe, by and large, don't believe that they can make as good a living in the arbitration environment as they can in the courts of the Bahamas. And this, Madam Justice, is one of the areas that we have to dispel. Because my understanding is that in the field of arbitration, it is just as lucrative, or maybe even far more lucrative, than fighting as we do in the courts. Hence, the obvious advantages of arbitration far outweigh any perceived disadvantages. Madam President, this is among the reasons why Madam Justice Ruby Nottage and the ladies you see, the distinguished panel of ladies you see there with her today, and others, have long called for the establishment of an international court of arbitration in the Bahamas, not to compete with the civil jurisdiction of the Supreme Court, but to complement the work of the courts through a simpler, faster, more peaceful, inexpensive option to litigation. It's noted by a proponent of the arbitration process, Sir Brian Murray, former Chief Justice of the Bahamas, who is also an advocate for the establishment of the Bahamas as an international arbitration center, or at least a regional arbitration center, akin to jurisdictions like Singapore, which we've heard today, Mauritius, or even Hong Kong. He suggested at a meeting on the subject sometime in 2016 that our natural and geographical advantages and attributes will serve us well in this regard. He noted that the Bahamas' proximity and accessibility by air, its mature legal system, its reasonably good infrastructure in logistics and communications, coupled with its efficient and friendly business environment, which is regarded as a sound and stable one, and its sophisticated financial and banking system, it bodes well toward us becoming significant players in the world of arbitration. And so despite the notion that we support the entrenchment of the arbitration process in dispute resolution management, the dispute resolution management arsenal of the Commonwealth of the Bahamas, it is my considered view that it is far past time for us to establish the necessary infrastructure to facilitate the establishment of such a center. You know, I want to speak directly to the Attorney General and the Minister for Economic Affairs. This is the stuff that legacy is made of. We were trying to do this for many, many years. Many, many years. Many, many years. And yeah. I just want to talk to my colleagues in a friendly way. You know, some of us can't take friendly banter. That's just the nature of it. But what we What we look at here is an opportunity to do something that those who preceded us have never been able to do, despite all of their best efforts. And so I believe we are in the right place at the right time to be able to make a difference. Trust me, I'll continue to work when you're gone, once we get it started. All right? So some advocates have proffered that Grand Bahama is ideally situated for the placement of the infrastructure. You don't agree with Grand Bahama? No, I saw that. In Providence. Well, that's a matter of logistics. That's a matter that we can work out. But what I want you to agree on is that we're going to make a concerted effort. I hope we can see something in the upcoming budget that will speak to. Hey, unless you're too far gone, I understand how that process works. And so based on the ruling by Lord Justice Ian Winder, as he then was, in the matter of Wolpe v. Delenson Services Limited and another 2018, Bahamian courts, I believe, are not averse to submitting trust disputes to the processes of arbitration. In that contentious dispute, the defendant sought to set aside an injunction made in support of an arbitral proceeding and on the service of the action on the plaintiff. In that case, the court determined that arbitral clauses contained in the trust instruments were, in fact, rightly done and should be supported. And so the mentioned clauses made it mandatory for any dispute relative to the validity of a trust, which, one, related to the establishment of effects of the trust, or two, between the settlor or the trustee, or three, between the protectors or parties to the trust, inclusive of beneficiaries, should be settled by arbitration. I believe this is the first time that this had happened in our country, and it was a good ruling, as Justice Winder, now Lord Justice Winder, our Chief Justice, is well known for making good rulings. And what the court determined, in essence, was that because you had built into the trust instrument the process of arbitration, there was no need for the matter to leave our jurisdiction or to be settled outside of arbitration, but to be settled through the processes of arbitration. All said, this outcome augurs well for the future of arbitration and the determination of trust disputes in this jurisdiction. Can you imagine contracts or instruments designed to honor contracts will have written in them a clause that says that these issues should be settled by arbitration? Labor contracts, building contracts, and the like. That will go a far way in helping us to achieve what we seek to do through these legislative amendments that we make. Too often we come to these places and we just make legislation, we just make amendments. We're all guilty of it, both sides. And we fail to put in place the necessary infrastructure that would push us in the direction where we all would like to go. I promise not to be long this morning, Madam President, before I take my seat. The Bahamas, without doubt, has the necessary base and framework, as well as the pool of talented legal personnel that we see sitting here today, such as retired judges and others, and senior attorneys at the bar, to make arbitration a firm part of our legal platform. We do. I believe that with all my heart. We simply need to access the global network of arbitration centers that are available to us, as noted by Sir Brian in his earlier mentioned remarks. There are resources available to us. The Hague, I believe it is, and other places, the United Nations, that will assist us in establishing the type of arbitration centers that we need in the Bahamas, not only to deal with international matters, but to deal also with domestic matters. How effectively might we use arbitration in these instances that we see domestically, particularly among our young people, who seem to have open season on each other because they simply don't know how to settle a simple argument, a disagreement. how effectively can we use arbitration in the war settlements in the Bahamas. So this is a very dynamic area of the law I believe that we should continue to look into, continue to pursue. And before I take my seat once more, I commend you, and I thank you for coming. And I hope we did you justice in this place today. I thank you.
Thank you, Senator, for your non-controversial contribution.